For me, it was a contractor. He learned the business, swinging a hammer, welding. We represented him through some pretty hairy situations, all of us pulling, trying to help him succeed. That's why I practice law, the same as you, because we want to help. Fully engaging in social media will allow more attorneys to help more people than ever before, but we've got to change our ethical rules to reduce the risks. Now, the public needs general legal information, high quality. And guess what? We've got it. Our very business is to create materials that withstand scrutiny by regulators and courts. Our stuff is right. And people are interested in what we're doing. If my client has a problem, others probably do too. Now, that benefit, it's not just for us, it goes both ways. The subject tonight is the end of irrelevance. And what's more relevant than right attorney working with the right client? Those intangibles that social captures so well, like shared alma mater, are just as important to delivering services and happy clients as your legal expertise. But legal ethics tightly regulates, is the opposite of social. It tightly regulates your relationships and duties, and it prevents the sharing of information. And it also presents huge risks to your reputation, loss of time, as well as scrutiny from legal regulators. Those regulators say, hey, just read the rules and apply them. Makes me think of my green snowboarding jacket. Here's the tag. And as you can see, it's kind of a pain to take care of. By the way, if you're taking a dozen uptight shots of a tag on your jacket, don't let your wife see you doing that. Now, let's get back to our helpful attorney. One thing that's undeniable is attorneys are busy. Think of all the things you've got to do in one day to keep the lights on. Then layer in a few tweets, a few posts on Facebook, maybe a blog post once a week. And that one tag that was kind of a pain becomes something entirely different. It becomes a burden like this. And so the takeaway for most attorneys is don't bother. But there's actually a double whammy, and that is the people who could add the most value, those careful, conscientious attorneys, are the ones most likely to avoid this morass. Well, who steps into a morass? Uber plaintiffs, vexatious litigants, the courts might call them. And these folks will use the rules for their own ends. Now, I don't need to talk to you about hypotheticals. Law professor Eric Goldman directs Santa Clara University's High-Tech Law Institute. He also blogs. Read anything that he writes. Here's his bio now. And he also helps the public by answering unsolicited legal questions in his area of expertise. I asked him about it. He said, quote, "I've had good fortune. I want to pass it on." Close quote. And so, knowing what he does, I was genuinely surprised when I saw this post. After helping literally hundreds of people, the time and stress of a couple bad apples overclaiming attorney-client relationships forced him to stop helping. The public, by the way, Professor Goldman taught legal ethics for 4 years. Now, the loss is not limited just to the public or the bar. It's a huge loss for regulators. One of the first issues is because writing legal opinions and ethical guidelines on social media is a thankless task. You've got to span everything from 1 billion plus member Facebook all the way down to the latest startup. And these platforms change within weeks, as do the way people use them. Personally, I'd rather be wearing a mink coat and selling hot dogs and ribs at a PETA convention than writing these ethical rules. There's also an additional loss for the regulators, and that is the more time they spend on social, the less time they can spend focused on attorneys doing truly bad things. So you ask, what's the solution? How about instead of trying to be all things to all people, how about we just focus on the harms that we're most interested in? Specifically, let's identify the harm that we're concerned about, determine what sites it occurs on, and then write specific rules for those sites. What else do we have to do? We have to de-stress. We've got to lower the temperature. How about a no harm, no foul rule for minor ad rule violations that occur on social media. Instead of a complaint, you get an email that says, if this is fixed in 60 days, no further inquiry into your practice. Additionally, if we're concerned about the formation of an attorney-client relationship, how about a disclaimer bar like we see here on all of our pictures and social media sites saying, I'm not your attorney unless. And then maybe we also include a URL with more information about when a person actually is hiring a lawyer. Finally, we've got to have uniform rules whenever possible. Lawyers whose practices touch multiple states cannot be reading dozens of ethics rules. Now, I know this is a huge change, but it's not a change of our hearts. It's just a change of the rules. This year is the 30th anniversary of Sony Corp versus Universal City. That's Universal Studios. That's the Betamax case. The 50th of New York Times v. Sullivan. And the 60th of Brown v. Board of Education. Attorneys, we do big change. Let's unbind ourselves and fix the rules. Thank you very much.